Law Matters. Of course it does. Welcome. I'm Debbie Moraes, your host and moderator. As we tell you, this program was created to educate, inform, and help you decide how to protect yourself, your family, and your business when it comes to legal matters. We provide information and resources that may help you manage some issues yourself. If you do decide to retain professional counsel, you'll be better prepared to work with whomever you select. Our goal is always to help save you time and money and to achieve the best possible results. And as always, we want to welcome and thank Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to give us insights and legal facts on all of the issues that we tackle. So today, contracts and sales agreements continued, or part two. As we said last time, they're intended to help all parties. We reviewed the elements of the contract, what consideration actually means, what makes one enforceable. We're going to discuss a little bit more about that today. And of course, we learned that not all contracts are created equal. In fact, some of them aren't fair, but they're still legal. Interesting. What about when there's not full disclosure? What about fraud? What about genuine mistake? All of these things need to be addressed and tackled. And do you need a lawyer to make sure these things are taken care of in the first place, as opposed to having a lawyer help you get relief once there's a problem? So we'll discuss that. And also, we'll talk about sales agreements. What do you need to know about them to protect yourself? Also, we'll talk about, or have you think about, telemarketers and some of those supposedly terrific offers, free but sometimes questionable, free trials, something called a negative option subscription. There are so many things that have been putting viewers in difficult situations. So let's get to tackle those. Let's pick up where we left off. Last time we were talking about contracts and what makes them unenforceable. We talked about it being under duress. I can't remember all of them, but address the ones, what happens when someone doesn't fully disclose or there's a mistake. Address some of those if you would, David.
So a couple of issues that you raised there. As we talked about the elements of contract before, one of the elements is that you have to reach an agreement on the same subject matter, and the issues that you're starting to raise there are whether or not there was a mutual agreement, or what we call under the law a meeting of the minds. So in order to get to a meeting of the minds, if, for example, there's not full disclosure on an asset, let's talk about a car, for example. What was the old thing? The little lady from Pasadena owned the car with like 2,000 miles on it and all of these other things. And what they didn't disclose to you was that, well, this car actually got shipped to Pasadena. The ship flooded, the car flooded, and there was all sorts of problems with the car, and that was not disclosed. So it was a misrepresentation of what you were actually buying. You thought you were buying a pristine vehicle, and the seller knew that there was problems with it and didn't disclose those problems.
So are those two things actually, one is not full disclosure and misrepresentation, both?
Well, it could be. If they didn't actually make an affirmative representation, but they sort of led you to believe by not disclosing the issue. It's actually the same problem. It's that you think you're buying one thing and the seller knows you're actually buying something else. So either by non-disclosure or misrepresentation, you have bought something that you didn't know was damaged prior and had issues.
So that brings up the other question that I started at the beginning of this segment, which is this an occasion where we need to have a lawyer because presumably you might know to ask all of those other little questions that most people might not? So if party A doesn't specifically ask party B about, and did something happen to that car that changed the nature or disposition of, you'd probably think about those things. Do we need a lawyer to review those things first so we don't end up with trouble?
Well, I was giving sort of a very specific example of a situation where you probably aren't going to bring a lawyer to the car dealer or to
Yes.
the person who's a private party selling a car or any of those things, but you should think about the general types of questions you want to ask about what you're buying. Now, if you're talking about some larger scale business transaction where those types of things need to be looked at, and the contract, if it's going to be an ongoing business relationship, should be looked at, that's a point where you might want to bring a lawyer in. But for every little, I need big or little, but for every transaction that you enter into in your daily life, you're probably not going to consult a lawyer before you enter into the transaction, unless it's on a scale of some almost commercial type where you're going to want to do that.
So if it isn't a commercial type, it's just, I'm selling my car to you, and I didn't enlist a lawyer in the first place, but now there's trouble. I somehow find out something went wrong with my car. I take it to a mechanic, and he says, lady, you have so many troubles. If I had to try to get some relief, what they call, however they label that, what would it come down to? Then I would need a lawyer. Then someone have to ask me, well, you should have known. How could I know that the car was underwater? How does that play out, David?
Okay, so what I would recommend in the first instance, depending on the situation, but since we're going down the road of cars, so to speak, I would say that before you buy the car, if you have a mechanic or can be referred to one, have the car inspected. A lot of times there's a pre-purchase inspection report that you can get on something before you buy it.
Good to know.
Not just a car, but really most anything. So if it's something that's not brand new and you're buying it and there's some concern, have it inspected before you buy it. And you may have to pay a little money out of your own pocket to do that, but if it's a big purchase, it's something you're probably going to want to do. And to go back to your second question, or your first question second, if you've now bought the car and there are problems, do you need an attorney at that point? Probably. But again, what the attorney is going to require is some information, some report from somebody, an expert or whoever in the field, if it's a car mechanic, to show what the problems were, what wasn't disclosed, and what that non-disclosure meant toward the value of the car.
What about if someone just plain old makes a mistake? They write up a contract, they're going to be buying something, selling something, or whatever, and they just either didn't know or they just made an honest mistake. What happens then, David, to a contract?
Is it a unilateral mistake or a mutual mistake?
So you get to go through both scenarios, David.
Okay. So if it's a mutual mistake by both parties, generally speaking, there's no meeting of the mind. The contract can be undone because neither side knew. What's an example of that? I think the example they used to give in law school maybe was that you're in the business of buying cows. You buy a cow that happens to be pregnant. Neither side knew about it. Are you able to get that undone, or does one side get the benefit of the bargain, so to speak, or not? As opposed to a unilateral mistake where I made the mistake, you didn't, but it's not like something you didn't disclose. It was just my mistake. Probably have a more difficult time unwinding that because, hey, you should have known and you could have done some due diligence to find out. So those are the types of things you need to look at. Does the mistake rise to the level of where there's no meeting of the minds, no actual agreement on something? And if it's just unilateral versus being a mistake by both parties, what's the consequence versus where you both didn't know what you were agreeing to?
Does this bring up the issue that when you're entering a contract, it's very important to write into it somehow how you manage to get relief if there are issues, whatever those issues are?
Yeah, that's actually a good idea because, and especially in a commercial transaction where you're going to want to be able to, let's say you're selling a product to somebody else to sell. You're the manufacturer. And so now we're selling you a lot of these items, and they want to be able to return some of the items perhaps for one reason or another. What's the agreement? What are the rules? That's something that usually is written into a commercial contract. You're not going to usually get that written into a consumer type of contract other than warranty. So warranty is a form of contract. Return policy, again, is another form of contract. So again, the issue with it is it's not usually something you're, as a consumer, able to negotiate, but you should know your rights with the seller before you enter into the agreement to buy the product.
And would the idea of arbitration or mediation be another example of you don't really get to negotiate that because I own the company and this is what I'm going to do? You get to know what the rights are, but you're not going to get to change if you don't like it.
So we're now starting
story?
to fall into that category of fine print, which in some instances could be considered contracts of adhesion, where meaning there's no equal bargaining power at the table in what you're going to have in terms of those contracts or not in terms. You see it a lot in leases, buying a car, the back of a lease agreement for a car, it's loaded with all this kind of language. You're not sitting there negotiating, well, no, I won't agree to that 5% penalty for the late payment. I'll pay 3%. Yeah, you're not going to be able to negotiate a lot of those terms. So what the court will often look at is, well, what's a reasonable expectation of the parties? If it's a reasonable expectation that some of those terms are what you're going to or would have agreed to anyway, the court's going to enforce them. If it's so overreaching and unfair, the court may have an issue in applying some of those terms to the contract.
So I read that unconscionable can make something a void contract, and yet, what was it in New Hampshire? I think I cited it in the last segment that when something was clearly not fair and reasonable, but it was clearly stated, it was considered to be legal. Aren't some of those things unconscionable, and who ends up deciding? Yeah. How does that play out, David?
Yeah, it's an interesting thing because different courts can have different interpretations of what happens when something is unfair or unconscionable and overreaching, so that there was no arm's length transaction or equal bargaining power. And as you said, New Hampshire sort of has taken this position that if the contract was clearly stated, even though it was unfair, we're going to enforce it, as opposed to other states that look at something and might say that is unenforceable because it is so unconscionable and unfair, and there was no bargaining power, ability to agree on terms of the contract. They were just imposed upon you. And so we don't think that that's fair, and therefore we don't think you really reached that agreement.
Okay. So let's transition a little bit to speak briefly about what sales agreements are. Who needs one? Does everybody need them, and does everyone need them to be written?
So usually those come in large ticket items. Mm-hmm. So you're buying a car, you go to the dealership and they have the agreement, they write out what car you're buying, what the price is, what are the terms of the agreement, what's included, what's not included. Big item purchases, usually you want to have a sales agreement so that there's clear agreement as to what you're buying and what you're paying and what the terms of the sale are. When you go to the grocery store, you're not going to have a sales agreement for the purchase of your milk. You're buying the milk, you know what you're buying, it's something you do every day. If you're in a commercial setting, you almost always want to have some either form of written agreement. And now we're falling under the terms of what's called the UCC, or the Uniform Commercial Code. And so there are terms that are actually sort of imposed upon the parties unless they change the terms of the agreement on the UCC. So there'll often be a pre-printed form that is used that says, for example, freight on board, whatever destination, FOB, whatever all those things mean. They mean something to people who are in the midst of commercial transactions. Who's paying for the freight? When does title or ownership of the goods pass? Why is that important? Because the risk of damage or loss of goods passes at a certain point, and who's that risk on? The seller or the buyer. So these are all certain terms that if you're in that business, you need to know and know what you're agreeing to.
So while we're not into the weeds about things commercial in this particular situation, there's sales agreement and then there's a bill of sale, and there are differences, and I think they sort of begin to address what you were speaking to. For most of us, we might be involved with more a bill of sale more
Yep.
frequently, I would guess. What are other triggers that we should watch out for, David?
So I think what you're really talking about is we have a sales agreement, which is the agreement between the buyer and the seller to sell a particular item. And then the bill of sale, which is signed at the time of payment, where the item is now transferred from the seller to the buyer. So if you're buying a car, if you finance the car, you know that there's a requirement at that point for you to get insurance on the car. If you're just buying it and you're paying for it, you still need insurance because the risk of loss is now passed to you. But the dealer doesn't necessarily get involved with making sure you have the insurance at that particular point.
And then real estate?
Real estate.
How does that play out?
Oftentimes we enter into a purchase and sales agreement. The purchase and sales agreement will have the price of the property being sold, the property specified as to what's being sold within the property, any personal property, fixtures, that type of thing. What are your rights to inspect the property before you have to close? Do you have a mortgage contingency? In other words, I can't pay cash for this, so I am going to be financing a portion of it, but I want a contingency in case I can't get the loan so I'm able to get out and get my money back. Also, where is the closing going to take place and when is the closing going to take place? So those are all the typical types of items that go into the real estate agreement. Now you go to the closing, and that's where title passes to you. You pay the money. You have to have your insurance on board and all the other adjustments that are made, which would be laid out in the agreement. Water and sewer, changing utilities into your name, all of that stuff needs to take place at the time of closing.
So always, whenever we're looking at contracts or certain sales agreements, there's always a question about you wanting to minimize your own risk. That's a value to you. When it comes to, say, real estate, you think you're buying a house on said date, that's when the closing is, and in the interim, I don't know, how do I minimize my risk? A hurricane came in between the day I signed it and the day we thought we were going to have a closing. Who needs to get involved with managing risk in that case? Is that a clear occasion when you need to have a lawyer on board to make sure that there's not some bit of minutia that will cause me, as the purchaser, unmitigated grief?
That language is actually typically included in a purchase and sales agreement for real estate. And it'll often say, not just a hurricane, but what happens if there's a fire or other damage to the property? Do I have to go ahead and buy it? Well, the title hasn't passed to you yet, so there's going to be insurance. And the owner of the property should still have their insurance in place. And now, do you buy it and get the insurance proceeds so that you can fix it, or are you allowed to get out of it? That language is usually in a contract. And generally speaking, if there's a large amount of damage to a piece of property and you didn't want to undertake a renovation project or have to fix property, there's an escape clause for you to get out at that point. There may be language in there that allows you to say to the buyer, to the seller as the buyer, you know what, you assign the right to the insurance proceeds to me, I'll fix the property and I'll go ahead with the sale. It's generally something that can be negotiated or worked out, but the language as to what your rights are needs to be in the contract prior to the catastrophic event taking place.
So that sounds like it's really likely to be in the drill down, if not in the 4-point mouse type, maybe it's 6, but certainly in the details. And while you were mentioning earlier insurance, countless people complain after they have an insurance policy, something happens and they have a claim, and somewhere they didn't discern the difference between full replacement value versus what the depreciated value was.
Right.
If you are a newbie homeowner and you're buying insurance, or even if you're a savvy and well-established homeowner, what do you suggest, what do you say to people about how to vet some of that kind of language? I mean, it could be a serious amount of difference between replacing the thing or the thing that's maybe worth half the value now and could be quite costly.
Especially when we're in that stage of the economy where prices of construction materials was
Exactly.
going up at an astronomical rate. It's come down a bit, But my advice would be, you're buying a home, especially if you're a first-time home buyer, contact an independent insurance agent.
Really?
And run it by them and ask them what types of insurance are out there for my home when I buy it, and what are the differences. As you say, what's the difference between we will give you the value of the home versus you want to rebuild the home, we will cover the replacement cost of construction of rebuilding a new home. And there's so many things that get put into an insurance policy. And if you ever looked at your insurance policy, it goes on for pages and pages and pages with all sorts of if, ands, and buts. And we'll pay for this, we won't pay for that. Do we pay for wind damage, water damage, hurricane damage, earthquake damage, all of these things. You need to speak to an expert in that area, which is generally an insurance agent.
Okay. One more follow-up question there. Is that something that an independent insurance person would be able to answer if you said point blank, what is in this that might cause me trouble later on? Is that a valid question for someone to ask?
Sure it is. And
so we suggest they do.
Yeah, and the first part of the conversation is going to be, what is the coverage? What coverage should I have? What coverage can I get? And they'll talk to you about all the different exemptions and exclusions and things that you generally can't get insured for, but what you can get insured for as well. Then if you want to take it a little bit further, you could ask them some of those questions like, well, what should I be aware of? For example, in an automobile policy, there might be some exemption about if you are a household member, but you're not named in the policy, what's the consequence of that? Things like that. So yeah, I would ask the agent, what should I know about?
Good to know. And in terms of other things that people buy, sometimes many people buy on the telephone thanks to a telemarketer. Interesting controversies come up when are they able to actually start to bill your credit card, and under what circumstances? And apparently that ends up getting more than cloudy or murky or whatever. They talk about express informed consent. I might have had an account with someone, so they have my credit card on file. If a telemarketer calls, and I engage with that telemarketer, that person has access to my account because I've been one who's purchased there before. At what point do they actually get to tap the credit card when they're talking to me? And what are the conditions under which they can do it? Apparently it gets to be, it says that it's supposed to be to protect me, like they will record the complete conversation. But tell us the last 4 digits of your card, Deb. Is that sufficient?
Yeah, so that's a tough situation.
It is.
And what really happens a lot is you'll get an offer, free trial. And then after whatever amount of time the trial is for, we will automatically start billing your card at X number of dollars. And what they'll do, especially if it's over the phone, is they'll say, we're going to record this, because they go through this whole spiel.
Yes.
You may have fell asleep during the middle of it. You may have listened to every word. But what's buried in all of those words is, we're going to bill you, and you're going to have to pay. And if you want to get out of it, you have to take an affirmative step. And taking that affirmative step, I found from my own personal experience sometimes, can be difficult because it's on your credit card bill every month. I don't want this anymore. In fact, I forgot I even did it. I never used it. I don't like it. Try getting them to take it off. You've got to jump through hoops sometimes. So it's something to really be aware of, and make sure it's something you really want, and know that you're going to get billed for it at some point.
It's interesting that they refer to the convenience to me of their having a pre-acquired account information, so I don't have to go rummaging through the purse at the last moment to give them all 12 digits and the CVRC, whatever it is in the back, CVV on the back. When they're giving a whole list of what the requirements are, what their terms are, I can only imagine that most people don't listen to, and on that 32nd day after the 1-month trial or that first shipment of the snake oil, we're going to begin to hit your credit card. Most people don't listen to that, and as you said, they don't know what to do. So first thing, look at your credit card. If it shows up on your credit card, you're likely to call the credit card company first. Credit card company usually says, call that vendor. How do you get to do that when you're in the middle of a telemarketing? Maybe it's not a high pressure sale, but you're in the middle of it. I want your personal cell phone number, Sarah.
Yeah,
You can't actually
probably,
ask
unless
for
it's
that.
something you really want or really need, the best way to resolve that is to say thank you anyway and end the call.
Yes.
Because you will have to jump through hoops to get out of whatever it is that you got for free that's not really going to be free after, in your case, the 30-second day.
The negative option, the fact that I don't call and say specifically, I don't want this anymore, has enabled them to trigger that call. Yet, it's suggested that when someone is offering you this free trial, this free subscription, they say it's actually not free at all when there's shipping. Well, there's shipping with everything if it's a tangible item. And that shipping fee may actually be worth more than the whole product is worth, but that's another matter. They often say you should go to the website and or go to call to see what your policies are for canceling after I've done it for 1 month, 1 week. I mean, we certainly have automatic charges on our credit cards that just make life simpler. I don't have to call my cable company. They continue to bill me, and I would not like it if they had to call me every month. So that's a convenience. But if I couldn't call and say, stop sending me that Venom oil,
Right.
you're in a bad situation.
Yeah. So, yeah, the shipping and handling fee, because the shipping fee is usually the cost of sending it to you. The handling fee is what do they charge
Whatever
for,
they want.
Yeah, shelving it, taking it off the shelf, putting it in the box, and those fees can be substantial, as you said. So one thing that occurred to me as you were saying all of that is when you're having the conversation, perhaps if you're good enough to do this, you should think about it. Okay, I heard what you said. I like your product. I want to try it. I want to use it. Give me all the information right now that I need, telephone numbers, who I ask for, who I speak to, what I have to say to cancel it on the 32nd day if I don't like it or don't want it. So maybe getting all the information up front and writing it down and keeping it someplace where you can find it so you can cancel it would be a good idea, because oftentimes what happens is you have it, it comes to you, you don't have any contact information, you don't know how to cancel it, you don't know what to do. You go to the credit card, as you say, you call them up, they say, yeah, well, you should call them. Luckily, sometimes on the credit card bill, or click through somewhere, if it's you can get your credit card bill online, is a telephone number where you might be able to call, might be able to get through to someone. You might have to push a lot of different buttons and try to find somebody. So maybe the answer is let's get that information up front so you're ready to cancel even when you want to cancel.
I guess we should say that if you have something on a credit card, if all else fails, you could say to the credit card company, stop payment on that now. I think that they need to do that.
Yeah, some credit card companies will do that. They'll say, you want to dispute the charge? Yeah, I want to dispute the charge. But then the other company will say, but they never canceled. So what happens with that, who knows?
Yet another buyer beware. We hope that this discussion about contracts and sales agreements and telemarketers and subscriptions has been helpful to you. As we say, stay tuned to The Law Matters. It matters to you. Thank you for tuning in.